Welcome to Moving Mom and Downsizing Dad, the podcast that prepares you for one of life's toughest yet inevitable moments, stepping in when your parents need you most. Hosted by Spade, a senior real estate specialist with Keller Williams Realty. We'll dive deep into more than just moving. We're talking smart financial planning, making tough decisions with confidence, and strategies to avoid being caught in crisis mode. Join us for real stories, expert insights, and actionable steps to stay ahead of the curve. Now, here's your host, Spade.
Welcome back to Moving Mom and Downsizing Dad, the podcast where we help Gen Xers navigate one of the biggest transitions they'll ever face, helping their parents downsize, age gracefully, and protect their legacy. I'm your host, Spade with Keller Williams Realty, San Diego Metro. Now, you may remember my first conversation with estate planning attorney, Sandy Isaac. It was packed with information, but honestly, there was so much gold in that episode, I wanted to revisit a few key takeaways. Now, today, we're breaking down some of the most important estate planning truths that every adult child needs to know. If you've ever wondered, do your parents need a trust? How long does probate actually take? How expensive is probate? And what happens if mom and dad can't make decisions anymore? Then you need to hear this. Now, I'm not an attorney. I'm not giving you any legal advice, but Sandy is. So let's jump into it with Sandy explaining one of the most common myths, and that is having a will means you're protected from probate.
A will is a ticket to probate. Just because someone has a will, dies with a will, you still need the probate court to validate that will. And now, guess what? The family gets a ticket to probate. They get to open a full probate proceeding, the same proceeding that if someone would have died intestate or without a will. So there's virtually very little difference of someone who died with a will or someone who died with no will when it comes to the probate process. Now, a trust is a private agreement, analogous to like a contract. It is a contract that says, I, during my lifetime, am putting certain property in trust to be managed post-mortem by my trustee. It does not require the court to validate that trust, and it is a private administration of someone's estate, whereas probate is public, right? If we have a probate and a will, that goes through probate, it's all public record. Everyone knows what you have, what your debts are. Trust is a private administration that only the people that are involved know about it.
And as Sandy just made crystal clear, simply having a will does not keep your family out of probate court. But beyond that, here's the real kicker, the timeline involved. Let's talk about why probate takes so long and why having a trust can save your family for months and months of agony or even years of waiting.
Yes, absolutely. So probably the biggest deterrent, other than the cost of probate, which I'm sure we'll get into later, is the time. Yeah, but the time, if someone calls me and I see them that day, the next day, we fill out all the paperwork for probate and I file it right away. It is the fastest filing ever, right? I file it right away. It's not my delay, right? As soon as I file it with the court, I'm going to get a hearing date. And that hearing date is probably a month from now, 45 days from now. And that's the first time a court's going to review my paperwork. And before then, I have to do a lot of steps. I have to publish with the newspaper. We have to send out notices. But in about 30 to 45 days, the court will approve the petition and order someone to be the administrator or the executor of the estate. We've just started the probate. All that is we got to the starting line. We haven't run the marathon yet. We've just got to the opening gates. And now, by the time we close a probate, which is you get the money, right? When you finally get the money to the heirs or the property to the heirs, at minimum, you're talking 9 months is a record pace probate. Typical, it's about 12 to 18 months. In certain counties, Orange County, you may be 18 months to 2 years just because of their backlog. LA County, different counties process things faster, but at minimum, you're looking at being, my client for at least a year.
And of course, time isn't the only issue. Money is a huge factor. This next part might shock you. Probate doesn't just cost time, it can wipe out a significant portion of your loved one's estate. Here's Sandy explaining exactly how probate fees work. Why don't we talk about the cost? Because the cost is set by the state, is my understanding correct?
Yeah, absolutely. So the cost is set by statute, which means you don't shop around for a cheaper attorney, right?
Yeah.
So whether you come to me in my beautiful office overlooking downtown and the water, or you go to the, solo guy that shops above a donut shop, it doesn't matter. It's set by statute, which means that I get paid based on a percentage of the estate at the close of probate. Now, Chris, I will tell you some really shocking news. Statutory fees are based on the gross value of the estate, not the net value.
Yep.
So if I have $1 million home with an $800,000 mortgage, I still get my statutory fee on the full $1 million. Even if, the proceeds were $150,000, yep. I'm getting it as if it was a free and clear $1 million, net proceeds. So it is, significantly more expensive. I mean, an estate plan is pennies on the dollar, right? You pay $5,000 for estate plan. I'm just throwing a, round number out there. You're going to pay maybe $40,000 for probate, of a similar estate.
Okay, so now you may be thinking, but how do I even know if mom or dad have a trust or just a will? That's where things get tricky. And this is where sometimes you have to play detective and put that detective hat on. Sandy explains how to start looking for clues.
How do I know if mom and dad had a will or trust, right?
Mm-hmm.
And I would hope that parents would share with their family members, but we know that that's not always the case, right? They may have some personal reasons for doing that. And now you have the children that are left with, we don't know what to do if mom or dad had a trust. Now, if they have real estate, reaching out to a real estate professional like you would be a very good first step, because you have tools to check title, right?
Yes.
You can check title and you can say, daughter client, your mom's house is in trust. I see a trust here.
Mm-hmm.
So you could be the first person to tell someone mom or dad had a trust. So now wesually if it's a trust that's prepared by an attorney, they may have their name on the letterhead, right, on the top of that deed. And then sometimes the family has to be detectives, and one clue will lead to another clue. Now, if we have a will, mom or dad just died with the will, we don't know. It's not recorded anywhere. It's not deposited. You don't go to the county and see if one's there. It really gets into the, boots on the ground, going through the files, anything that you can find in the documents. And unfortunately, the law presumes that a will is void or revoked if it physically cannot be found.
And here's the thing, too many families don't have these conversations early enough. Life gets busy, people put off, and suddenly it's too late to do proper planning. As Sandy says here, you can't create a trust after you're gone. So the sooner you tackle it, the better.
Well, the first step is, deciding to do it, right? A lot of my clients, it's been on their to-do list for years. And the number one comment that I get from clients are, oh my gosh, that was so much easier than I thought, right? In our head, we tell ourselves stories about, we'll do this later, we have to do this first. But really, it's just calling up, right, an attorney or getting a recommendation, contacting me, whoever you know or trust, and making an appointment. And typically the process is the attorney will meet with the clients, will gather certain information, Some attorneys do it through like a worksheet, right? I use a worksheet. A lot of my colleagues do, right? To get all your family information, the stuff you know, right?
Right,
Names,
right.
birthdays, addresses, things like that. And then we go over the details of what does your estate look like? What are some of your unique challenges that maybe we need to talk about? But we get the information. Some people are easy, right? I got 2 kids, everything 50-50, easy peasy.
Mhm.
Or, yeah. And so we gather the information and then I prepare the documents and then I sit down with my client. We review it. We make sure it's exactly what they want. We sign it and notarize in the office, and that's it. It's a
Done.
very simple process.
Hey, real quick before we wrap up, if you're finding value in these conversations, please do me a huge favor. Hit subscribe or follow wherever you're listening right now. And if you know someone who's helping their parents downsize or navigate estate planning, share this podcast with them. These conversations are here to help you before crisis happens. Thank you for being a part of Moving Mom and Downsizing Dad. Now back to the show. Now, once you've made the decision to create a trust, next big question becomes, who do you pick to manage it? And believe it or not, it's not always the one who's the oldest or the closest to you. Here's Sandy on how to really choose the right trustee. Who should you pick as your trustee? Because, like, for example, my parents, my dad's trust, my brother, younger brother, lives in the same state my father does. I live here in California. We've already agreed that my younger brother, he's there, right? It just makes sense, right? But who should be your trustee in this case?
So that's an excellent question because most individuals choose their successor trustee based on one of two criteria. Who's the oldest, right? They'll just choose by age, or who lives closer, like your dad, Chris, right?
Mm-hmm.
You said who lives closer. That makes sense. I would encourage my clients not to choose based on those two criteria, which are the most common, but choose based on who has the skills to do this job. Maybe brother who lives right by dad is a nurse, right? And he's excellent at these things, or he's an artist, right? Or he's, something that doesn't really deal with paperwork or legal or real estate. Whereas Chris is all the way in California, but he's a real estate professional and he has the contacts, right? He can handle paperwork. So what I do is I sit down and I talk about who's in someone's family, and we talk about what does the job of a trustee entail, right? What do they have to do? And then which child has the skills really to do that job?
Of course, not everyone has a clear option in their family. What if none of your kids is responsible enough, or you simply don't want your family in charge? Sandy walks us through what to do if you need an alternative naming your children as a trustee. Well, what if, in this scenario, just throw it out there, what if somebody does not have children, or they don't really think either one of their children is responsible? What would you recommend in a case like that?
And that is common, right? Sometimes clients don't want to put, even if they had a responsible child, they don't want their children to be, one of them be the boss or have authority over the other, or their children are just really not good choices, right? They love their children. They want their children to receive the benefits of their estate, but they recognize that their children are really not capable of doing this job. Right. Or they don't have someone in their family, right? They don't have children. They don't have family members that really, have those skills. Maybe there's a language barrier, right? I deal with a lot of Latin American clients, and sometimes just the language or understanding how the system works here is not a good fit. So what we do in those situations is most attorneys recommend private fiduciaries, right? Private professional fiduciaries, that is their job. They're professional trustees. They know what to do. They are licensed. They're bonded, right? They will be neutral. They're not going to pick a side because, sometimes when you get siblings, you get all this childhood things that come up, right? Well, mom loves you more because they bought you a
Yep.
car when you graduated and I didn't get a car. We discuss private professional fiduciaries, right? They get paid from a percentage of, they get paid typically hourly from the estate. So it's not like you have to pay them in advance. Or is there someone outside the family, right? A trusted uncle or another friend, a good family friend, right? So we explore the different options. Last options that we explore is professional fiduciaries like banks, right? Trust companies. There's a lot of trust companies within banks or their own, separate trust companies. So sometimes we'll explore those for higher net worth clients.
And so, just to be clear, they're the ones that are signing on behalf of the trust, like selling a house or, signing checks, those types of things, correct?
Absolutely. That is their job, is the taxes of the estate, collecting all the assets, the money, paying all the bills and debts, distributing, selling real estates, all of that.
Now, let's be honest. Is setting up a trust emotionally easy? For many people, not at all. It's hard to face mortality, family dynamics, and complicated relationships. But as Sandy explains, while it may be uncomfortable for a short time, in the long term, benefits far outweigh the temporary discomfort. So we've talked about the benefits of the living trust. This really avoids probate. That's a big thing. Are there any drawbacks to having a trust?
I mean, initial startup costs, right?
Okay.
It's with probate, it's not your problem, right? By definition, you're dead, and it's a problem for your loved ones and your heirs. Whereas a trust, I mean, you have to pay for it. So, that's a drawback for some, is that, it's not, a cup of coffee, right? But it's not
Right.
the price of a car. So, that could be a drawback. And for some people, it's confronting those realities, right? Confronting mortality for
Right.
some is very hard. Culturally, for some people, that's very difficult. You don't talk about these things, or you have to confront your feelings about your family, right? You have to confront that, you have to tell your attorney that your daughter has a substance abuse issue,
Yeah.
right? So it's or, all these situations that are very emotional and very private. And often we don't like to talk about these. So it's uncomfortable. So that's a drawback for many, is just being uncomfortable for a little time, depending on your family. But other than that, Chris, it's one of the few things in life that almost all benefit and very little drawback.
And finally, one of the most important parts of estate planning, and the one that often gets overlooked, is planning for incapacity. What happens if mom or dad can no longer make the decision for themselves? Here's why having the right documents in place is absolutely critical.
Well, statistically, 50% of Americans will become incapacitated at some point before their death, right? And we don't know if it's a long-term incapacity, right? You mentioned a couple cognitive, factors, right? Dementia, Alzheimer's, and those individuals with those diagnoses, it's a progressive disease. They can live for years with diminished or lacking capacity, right? Or you can have a short-term capacity, but I mean, it's pretty good odds that, you will be incapacitated at some point before you pass. Now, a good estate planning attorney and a well-rounded estate plan is going to have incapacity planning documents.
Okay.
So you're going to have, as part of the estate plan, so if we have a trust-based estate plan, we're also going to have other documents or ancillary documents. Specifically, to assist with incapacity, we're going to have financial durable power of attorneys, and we're going to have advanced healthcare directives. So whereas the trust and wills are the, what happens when you die documents, so to speak, post-death, the advanced healthcare directive and financial power of attorneys are our living documents, right? If mom becomes incapacitated, then that financial power of attorney will say, son Chris can step in and manage her finances, pay her bills, pay her taxes, right? Maybe mom has to go to assisted living, and really it's her home that's the biggest asset. Son Chris can sign to sell the home, hire a realtor, just like if it was mom. The healthcare directive is, son can go in and make decisions for mom, take her to the doctor, get her treatment when she can't consent or is unable to make those decisions. Unfortunately, if someone doesn't have those incapacity documents, the alternative is we're back to court with conservatorships. And conservatorship is like a living probate almost, whereas someone is appointed to manage the affairs, make decisions for someone who's incapacitated. And it's very expensive, and it's for the life of that individual.
That's going to wrap it up for this special replay episode with estate planning attorney Sandy Isaac. Now, if there is one thing I hope you take away, it is this: don't wait. These conversations are hard, but they're also much easier when you have them ahead of time. Now, before you are forced into probate court or dealing with a medical crisis, have these conversations with mom and dad. Sandy will be back in future episodes to dive even deeper into estate planning and probate and all things you need to know to help your parents and eventually for yourself navigate these life transitions with confidence. In the meantime, if you need help navigating your own situation, whether that's selling your family home, figuring out the probate process, or just having someone guide you through the downsizing process, reach out anytime. I'm Chris Spade with Keller Williams Realty, San Diego Metro. Thanks again for listening to Moving Mom and Downsizing Dad, and we'll see you next time.